Welcome to the fifth in a series of webinars focusing on rural disputes. My name is Stephanie Hepburn. With me is my colleague Elaine Brailsford. Together we're part of the team specialising in resolving rural disputes. Today we are delivering part 2 of a two-part webinar on access rights in the rural sector. In this part we'll firstly look at the remedies available when disputes about servitudes arise, and secondly look at public rights of access. In this webinar, we'll continue with the semi-fictional scenario we used in part 1. As you may recollect, we left Farmer Brown with a dispute with his neighbours, Mr and Mrs Smith. Mr Brown's farm, Area A, is shown outlined in red on the screen there. Area B, owned by the Smiths, is shown outlined in pink. The access path at the top, outlined in green, leads to the local shop and school. It's also owned by Mr and Mrs Smith, but the path was never part of Mr Brown's title. You may recall that Mr Brown was concerned the Smiths were planning to put up a gate on the access path, which would prevent Mr Brown using it to get to the shop and the school. Elaine advised Mr Brown it was likely he had a right of access by prescription over the path, and the Smiths were not allowed to obstruct it. Sense prevailed, and the Smiths agreed not to install the gate. However, they've since reneged on their plans, and the gate has been installed, and they've not given Mr Brown a key. Elaine, what remedies are open to Mr Brown?
Well, if Smiths are unwilling to remove the gate by agreement, Mr Brown may require to raise an action for declarator that his property benefits from a prescriptive right of access over the path, and this would be based on the historic use of the path by his family. And this would mean that the Smiths would not be allowed to obstruct Mr Brown from using it. Now, affidavits will be needed to be taken from Mr Brown, his family, and anyone else who can speak to the use of the path. In the same court action, he should seek an order requiring the Smiths to remove the gate or to give Mr Brown a key, and also for interdict and interim interdict to prevent them from obstructing the access path in the future.
Well, Mr Brown is happy with that, but you might recall the Smiths converted an old steading on their land to a restaurant and took access via a road on Mr Brown's land, you'll see in the slide there, that the Smiths had an express right over. Mr Brown was angry about the volume of traffic on the road to the restaurant and the fact that cars had begun to park on his land. Elaine, what if anything can Mr Brown do about this?
Well, he may be able to divert the route of the servitude that the Smiths have. If there's no route specified in the servitude, then Mr Brown can apply to the court to vary the route. If there is a route specified, the court has no jurisdiction to vary it, but the Lands Tribunal does. So Mr Brown could apply to the Lands Tribunal under section 91A1 of the Title Conditions Scotland Act 2003. The Lands Tribunal can only vary the route of the servitude if it's reasonable to do so, and they'll take into account factors such as the change in the character of the Smith's property, from a farmsteading to a commercial restaurant. Now, the Tribunal will look at the purpose of the access right and whether Mr Brown is willing to pay compensation to the Smiths for varying the route.
You might also recollect that Elaine also advised Mr Brown the increased flow of traffic on the road is unlikely to amount to an unwarrantable increase in the burden, because it was always a plan that the Smiths' land would be developed for housing and the access road would be used to get to the houses. However, she also advised the Smiths are unlikely to have a right to park on Mr Brown's land, either as a servitude in its own right or one that's ancillary to the right of access. So what can Mr Brown do about the parking then?
Well, parking is a very vexed issue. You can obviously interdict someone from wrongful parking if you have their details, but you can't interdict the public at large. Mr Brown can raise an action against the Smiths for declarator that there is no servitude right of parking and interdict the Smiths from parking, and that might cover those acting under the Smiths' direction. But if you have a persistent parker and you can demonstrate a case that if you have a persistent parker and you can demonstrate a case, you might be able to obtain details from the DVLA, and that would enable you to take an action against them, either for removal or interdict. But this is obviously not without some difficulty. And this is where self-help remedies may come to the fore. You might block them in, for example, but you have to be very careful with self-help remedies not to cause any damage, because if you do, you will be liable. And of course, if you block them in, that's not removing them from the land, indeed quite the reverse.
Well, moving on to Chapter 2 of Mr. Brown's story. Having resolved all of these issues, Mr. Brown is faced with a second dilemma. He had recently bought a new house nearby that he plans to retire to, leaving the current farm for his children. The house is set in land of around 20 acres, and you'll see it on the slide there. I should say at this stage we have used a bit of artistic license in relation to the slides and the scenario. It might not exactly reflect reality, but hopefully you get the idea of the kind of scenarios we've had to advise on in the past. You'll see the land's got a small pond there with some decking Mr. Brown plans to use in the summer. He also wants to install a barbecue area, which you'll see, and a play area for his grandchildren. He's begun to spend some weekends at the new house to get a break from his children. One weekend he was shocked to find a group of walkers walking very close to the house along a rough track that you'll see mostly outlined in black on the slide. He also saw a cyclist, someone walking their dog, a runner, and even someone riding a horse. One of the walkers mentioned to him people in Land Rovers often drove over the track too. Mr. Brown is appalled. He wanted peace and tranquility on his retirement, not to mention privacy. He's also concerned the public may start to fish in his pond. Mr. Brown now gets in touch with his trusted advisor Elaine, concerned the track is a public right-of-way, and by using it, the walkers and runners are exercising their right to roam. Elaine, what's the first thing you do?
Well, Mr. Brown does seem a little bit confused, I have to say. He mentions on the one hand a public right-of-way, but he also mentions the right to roam. And as we'll go on to discuss, these are two completely different things.
So what is a public right-of-way then?
Public rights-of-way have been in existence since time immemorial. They are formed by people using the same route for a number of years without challenge, provided certain conditions are met. People are often surprised that there are public rights-of-way in Scotland, but anyone that's journeyed through the Scottish countryside may well have come across them. Many of the most famous routes in Scotland are rights-of-way, for example, the Larry Grew, Glentilt, the Minigig Pass, the Gate Pass, Jock's Road, for example.
So is that different to the right to roam then?
Yes, it is different. Until 2005, when the right to roam came in, public rights-of-way were the main form of legally protected access in Scotland. Now, this changed with the introduction of the right to roam on the 9th of February 2005. Part 1 of the Land Reform Scotland Act 2003 now gives everyone rights of access over all land and inland water throughout Scotland, unless the land is excluded. And we'll discuss the exclusions in a moment. These rights are often referred to as rights to roam. The public must act responsibly in exercising their right to roam, and the Scottish Outdoor Access Code gives access on what behaving responsibly means, both for land managers and for those exercising the right. Now, to avoid confusion throughout this webinar, we'll refer to those rights-of-way created by use as a public right-of-way, and the access rights created by the 2003 Act as the right to roam. But the right to roam is often referred to as a public right of access.
So the public right of way and the right to roam are not servitudes then?
No, they are not. Servitude of access is a private right only exercisable by the owners of the property having the benefit of the servitude, not by the public at large. However, as we touched upon in part 1 of this webinar, a private servitude of access and a public right of way may coexist in relation to the same land.
So how do public rights of way and the right to roam work together then? Is Mr. Brown required to establish if the track that runs through his land is a public right of way, or if the public are simply exercising their right to roam?
Well, even after the introduction of the right to roam, public rights of way continue to exist and be relevant. A public right of way is a right which allows the public to get from one public place to another public place. But the right to roam has much wider application. It applies to all land in Scotland unless it's caught by one of the exclusions set out in the Act. And it allows the public to do a lot more than just pass. For example, it can extend to wild camping. Now, we'll come on to the exclusions in more detail in relation to Mr. Brown's land, but one exclusion from the right to roam is that it must be sufficiently adjacent to properties. A public right of way may be vehicular, but the right to roam cannot be used for motorised access. So you may have a situation where land adjacent to a property is excluded from the right to roam, but is still a public right of way. Now in this case, you can only use the public right of way to get from A to B. You cannot camp on the land, for example. Or you may have a situation where the public wish to take motorised access over land, which they couldn't do exercising the right to roam, but they may be able to do if there is a public right of way. Now, because of these differences, Section 5.3 of the Act makes it clear that the right to roam does not override or repeal any existing public rights of way.
So let's look at Mr. Brown's situation then. Looking first at the right to roam in the 2003 Act, what advice do you have for Mr. Brown in that regard? Would the right to roam allow the public to cross his land in the way he's described? They've got walkers, dogs, runners, horse riding, even people taking access in Land Rovers. Does the right to roam allow them to do that?
The right to roam allows the public to be on or cross land for recreational purposes, carrying out relevant educational activities, and limited types of commercial activities. Well, those on Mr. Brown's land who are walking, running, walking their dogs, etc., surely that's recreational. There are many types of activities that can broadly be classed as recreational. The Scottish Outdoor Access Code includes pastimes, family and social activities, active pursuits, participation in events. I mean, it's really very broad. And it will include activities from sightseeing, watching wildlife, picnicking and walking the dog, horse riding, rock climbing, canoeing, and, as you've said, wild camping. You also have people participating in sport, marathons, triathlons and other sporting competitions. So it's likely the walking, running and horse riding that Mr. Brown has seen to date would be covered. What about the Land Rovers? The right to roam does not apply to motorised activities like off-road driving or motorbiking. So these will not be allowed unless Mr. Brown gives his permission, which of course he's not obliged to do. The only exception to this is that someone with a disability may use an adapted vehicle to enable them to exercise their right to roam. What about fishing in his pond? Mr. Brown is worried about that. Can the public use the right to roam to fish in his pond? No, Section 9 of the 2003 Act makes it clear fishing is excluded from the right to roam, as indeed is hunting and shooting. And you mentioned educational and commercial activities. Well, what does that cover? Well, the public can use the right to roam to further their understanding of natural or cultural heritage, or to help others to do so. So school trips to see how a farm or estate works, or to see a particular attraction, such as an important wildlife site, will be covered by the right to roam. The public can also use the right of responsible access to carry out commercial activities so long as they are recreational activities. What does that mean? Well, it's a bit obscure, but say someone received money to act as a hiking guide and took hikers over Mr. Brown's land. That would be a commercial activity for him, but because hiking is a recreational activity, it's allowed. But if someone brings on a cool box onto Mr. Brown's land and starts selling drinks, that would be a commercial activity and not a recreational activity, so that would not be allowed. So Mr. Brown is pleased that in the context of the right to roam, he can prevent the public fishing and driving the Land Rovers. He still doesn't want the public walking, running, riding horses on his land whilst exercising the right to roam. They're coming really close to his house. He's told us around 20 metres from his house. What further advice might you give Mr. Brown? While the right of responsible access may appear to be very extensive, it is subject to many restrictions, and we need to think about whether the land over which the public are walking, in this case, is actually land to which the right to roam applies. So Section 6 of the Act lists land over which the right to roam cannot be exercised, and that is on the slide there. The most important one for Mr. Brown is Section 6(1)(b)(4), which exempts sufficient adjacent land to properties from the right to roam. This is so that the right to roam does not cover private gardens or space too close to a home, so that homeowners can have some privacy and enjoyment of their home without being disturbed by the public.
Well, that exclusion might help Mr. Brown, but how much land is actually excluded from the right to roam to give him sufficient privacy?
The test to determine this extent is what a reasonable person would deem appropriate in the circumstances. It's unlikely the whole of the large estate could be blocked off for access rights for privacy purposes, so that I think would be excessive.
And are there any sort of similar cases that might help Mr. Brown? I read recently about a new case about some land out in Penicuik.
Yeah, I think you're talking about Mr. and Mrs. Manson against Midlothian Council, which was decided in September this year. That was all about the right to roam. The Mansons owned around 0.21 hectares of land. It was in a suburban and semi-rural area in Penicuik. And they built a house on this plot of land, and the land included part of a path that was used to access Penicuik Estate. And when the house was built, it was built around 20 metres from this path. Now, the Mansons installed an 8-foot-high fence with a locked gate across the path, thus restricting access to the path. And the fence was painted with anti-climb paint and had a number of signs on it, and a placebo CCTV camera was in place. They really didn't want people coming in. The fence and gate were put up, actually replaced a kissing gate and a metal 5-bar gate, and that was found that it was not normally locked. Now, Mr. and Mrs. Manson argued that their privacy was impacted by the path. But the evidence that was led was that it was not all that easy to see into the house from the path. The Mansons were also concerned about noise levels on the path, as well as visibility. Now, in assessing whether the land fell within the Section 6(1)(b)(4) exclusion, the Sheriff made it clear that an objective test must apply, taking into account the circumstances of the case and the characteristics of the house and the land in question. Now, the Mansons had an autistic son, and they were concerned about the effect of such access close to the house might have on their son and other related sensitivities. But these did not factor into the Sheriff's decision. The Sheriff held that the path was not land that fell within the 6(1)(b)(4) exclusion. She did not think that a path that ran 20 metres away from the house could be classed as adjacent.
Well, that doesn't sound too promising for Mr. Brown then, as the track in his case also runs around 20 metres from his house.
Well, I understand the Mansons have appealed the Sheriff Court decision, but in any event, I think we need to remember that the Mansons' property was in a suburban or semi-rural area, and Brown's new land is deep into the countryside, surrounded by forest and little else. The test is whether a reasonable person living in a house, like Mr. Brown's, located in the countryside, would view their enjoyment of their house to be considerably reduced if it was not accompanied by reasonably large private grounds.
So, is what you're telling us is that each case turns on its own facts and circumstances?
I'm afraid that old adage is particularly true in this case, yes. Section 7(5) allows the courts to look at factors such as location and characteristics of the land and the house, but these must be viewed objectively. A case that was well reported in the news at the time was that brought by Anne Gloag of Stagecoach fame, and the court found in her case that she was entitled to privacy over an area of her estate at Kinfons Castle that extended to 12 acres. Now, at the time of her purchase, there was a run-down fence and a dry stone wall running along a large part of the boundary, and Mrs. Gloag erected a more substantial 6-foot wire fence topped with barbed wire along the line of the existing fence. for which planning permission was retrospectively granted. This fence created a 12-acre enclosure which entirely surrounded the castle, including areas of woodland, and it prevented entry to the property other than climbing over the fence or entering through the main gates. The local authority and the Ramblers Association intervened in the case to seek to have a section of the fence taken down under the 2003 Act, so that the woodland, which formed part of this area enclosed by the fence, could be open to the public. Mrs. Gloag argued that the fenced area, including the woodland, was an exception in terms of Section 6. Now, the Sheriff commented that the Act itself gives very little assistance to those making a decision as to how much land falls within the definition of what is land adjacent to properties. He looked carefully at the area which Mrs. Gloag could reasonably expect to be considered private and therefore exempt. He looked at matters such as the siting of the children's garden toys and swings, the barbecue area, her plans for extension, and the topography of the area surrounding the castle. And the Sheriff concluded that Mrs. Gloag was entitled to fence off the 12 acres of land to protect the privacy and security of her family and guests, including royalty, heads of state, and celebrities. Now, this authority may help Mr. Brown, but we need to bear in mind in the Gloag case, the court accepted her need for a higher than usual security due to press and criminal interest in her activities, her family, and her possessions.
So where does this leave Mr. Brown then? The track does run right through his garden, around 20 metres from his pond and decking and his house. Surely it is part of his garden then and should be excluded from the right to roam.
Well, whilst the term garden is not actually used in the 2003 Act, the Access Code uses garden for land adjacent to a dwelling. It also suggests what sort of land the exclusion applies to, highlighting features such as grass, flower beds, paving, water features, sheds, summer houses, vegetable, fruit gardens, etc., all relevant for determining whether land close to a dwelling is a garden. Having said that, the Access Code is not definitive in accessing where access rights can be exercised, and it's ultimately for the courts to decide. Now, in another case, Snowy against Stirling Council, in 2008, Mr. Snowy sought to exclude 70 acres of ground around his house, which was almost the entire estate. He wanted that excluded from public access on the grounds of privacy, and he claimed security. Access gates had previously been available both to cars and those on foot were locked. But his attempts failed. In the eyes of the court, to prevent access to that amount of land was not needed for the reasonable enjoyment of the property, nor was it needed for security reasons. And the Sheriff did allow a restricted area of around 10 acres, and that was excluded from the right to roam. And there's been another case, Creelin against Argyll Butte Council, 6 acres of land was excluded in that case.
So, looking at Mr. Brown's case, what do you think a court would decide here?
Taking the facts and circumstances into account, I think the track running next to Mr. Brown's house, the pond, the decking, would be held to be part of his garden and adjacent to his house, and thus excluded from the right to roam.
That's promising for Mr. Brown. He now wants to put up a gate and block off the access altogether, and also put up a sign saying private land, keep off. Can he do this?
Well, assuming there's no case for a public right of way, yes, he can do this. He can put up the gate, he can block off the access, he can see if anyone objects and try to establish that they've got the right of access to roam over the track.
And what if someone does object?
Well, if they do object, Section 14 of the 2003 Act prohibits signs, notices, obstructions and the like that have no purpose other than restricting access rights, and allows the local authority to serve a notice requiring obstructions to be removed. So if he was sure that that there was no right to roam, and he did put up his gate or his notice, then there is a risk, of course, that the local authority will serve him with a notice and claim that he's obstructing the exercise of the right to roam.
And what if Mr. Brown fails to comply with such a notice?
Well, the local authority can remove the sign and the gate and seek to recover its reasonable costs.
And what should Mr. Brown do then?
Well, then he can apply to the court under Section 28 for a declarator that the track falls within Section 61B4. That's the exemption, that the public cannot exercise their right to roam over it. And it's worth noting that interested groups such as community bodies or Rambler Scotland can intervene in these proceedings, and that's actually what happened in the Globe case.
Well, Mr. Brown's reassured to hear this, though. However, before he goes off to court, should Mr. Brown be thinking about, as you've mentioned, if the track may be a public right-of-way?
Yes, even if the track is excluded from the 2003 Act, there's still the possibility that it is a public right-of-way which has been created by use.
And is there any way for Mr. Brown to tell this without incurring more legal costs? Is there a record of them kept anywhere?
No, there's no legal requirement for a right-of-way to be recorded anywhere. So any route that meets the conditions of being a right-of-way will be a right-of-way. No further action is necessary. However, ScotWays maintains a national catalogue of rights-of-way called CROW, and CROW is not available online, but you can find out more information by contacting ScotWays office. Local authorities will also have their own records of rights-of-way.
Well, in this case, Mr. Brown contacts ScotWays and he's advised there is no right-of-way over the track recorded in CROW. Is that the end of it then?
No, it's not. It's really important to note that CROW does not include all rights-of-way in Scotland. It's not determinative. Many of these rights-of-way are known only to local people and only come to ScotWays notice sometimes when there's a problem.
So the track isn't on ScotWays CROW register. How does Mr. Brown go about assessing if the track is indeed a public right-of-way?
Well, the test contains actually a number of elements, and this is set out in Section 3.3 of the Prescription and Limitation Scotland Act 1973. And the test is very similar to that which we discussed in the last webinar in relation to prescriptive servitude rights of access. So Section 3.3 provides, if a public right-of-way over land has been possessed by the public for a continuous period of 20 years, openly, peaceably, and without judicial interruption, the right shall be exempt from challenge. Now, there must be a public place at either end of the way, a continuous journey from end to end, a definite route, possession by the public as of right, and it must be open and peaceable use for the 20-year prescriptive period without judicial interruption.
Okay, let's take each of these tests in turn then and apply them to Mr. Brown's situation. Looking firstly at 1, there must be a public place at either end of the way. Is that satisfied here?
Well, the route must run from a place where the public are entitled to be to a place where the public are entitled to be. And that's a quote from a case back in 1866.
So if either end of the track that runs through Mr. Brown's land is not a public place, it can't be a public right-of-way.
That's right.
Well, we can see from the map of Mr. Brown's land, the track starts at the fictional A123 road on the east there, runs through the forest, through Mr. Brown's land, continues through the forest, and ends at the churchyard of a local church. Is that a public termini?
Yes, a public road is the most obvious example of a public place, and churches and burial grounds have also been held to be public places. But surprisingly, airports have been held not to be a public place for the purpose of establishing a right-of-way. In a case, PIC Facilities Limited against Watson's Air Park in 2005, Prestwick Airport was held not to be a public place because the public does not have a right of access to all parts of it at all times. Similarly, in Lovely against Cameron of Lochiel in 1991, a post office in a private home was not a public place, and neither was a cattle market, which was open 4 days a week, which was the case in Ayr Borough Council against British Transport Commission, 1955.
So looking at part 2 of the test then, there must be a continuous journey from end to end. What does that mean?
Second part of the test is really there to distinguish between those who use the whole of the route from end to end from those who may only use part of it or enter and exit from the one end of the route.
Well, it seems from what Mr. Brown has told us about the use of the track that that's satisfied.
Yes, I think so.
Looking at part 3 then, that there must be a more or less defined route. Is a track a defined route?
Yes, the track is evidence of a defined route, although Scots law does recognise that it's unlikely that you will follow precisely the same ground every time. So, proving that a definite path or track has been followed isn't actually necessary. There may be detours or deviations due to landslips, for instance, or weather. And that doesn't necessarily mean that a defined route's not been followed, provided the route's capable of use from one end to the other.
So that satisfies Mr. Brown's case then. Looking at element 4, that the route must be possessed by the public as of right, what does that mean?
Well, it means that the use of the path must have been without the tolerance or acquiescence of the landowner. That is, as if the public right-of-way existed. The requirement that the route is possessed by the public really means that the public must have used the entire length of the route fairly regularly.
Well, Mr. Bryan has only just bought the property, so investigations will need to be made in that regard. Mr. Bryan has talked to previous owners, any neighbours, to establish exactly what the historic use of the path has been. Moving on to the last part of the test then, that the use must be for a continuous period of 20 years, openly, peaceably, without interruption. I suppose Mr. Bryan will have to get historical information on that too.
Yes, the use must not be by stealth or violence, and it must not be interrupted by the landowner or by legal proceedings designed to defeat the existence of the right. And the use must also have been continuous for 20 years.
Does that mean every day or every week?
What is continuous really depends on the facts and circumstances of the case. It's not necessarily daily or even weekly. But the courts will look at factors like the nature of the route, its location, and the density of the population.
We learned earlier on that a right-of-way can be vehicular, so would the Land Rovers be allowed if there's a public right-of-way then? And what about the horse riding?
The extent of the possession determines the extent of the right. So, if the Land Rovers and horse riding has been done regularly for the required 20-year period, then it's likely that this will be part of the right-of-way. But if there's no evidence that driving Land Rovers or riding horses over the track has been done over 20 years, the right-of-way will not extend to these.
Well, upon investigation, Mr. Brown is able to establish from the previous owner the public only began to use the track a few years ago when the fictional A123 road opened. Before that, no access was taken. Elaine, does that mean it's not a public right-of-way? And if so, what should Mr. Brown do to stop access being taken?
Yes, if there has not been 20 years, then there will not be a public right-of-way. Now, Mr. Brown, if he's satisfied there's not also a right to roam, of course, can put up a gate and a notice at the entrance of the track to deter access. He might also want to contact the local authority's access officer and advise them that there is no public right-of-way here. And if there is an objection, then Mr. Brown can raise proceedings for declarator that there is no public right-of-way, and he might want to seek interdict and interim interdict against anybody who is seeking to use it.
Well, that all sounds promising for Mr. Brown. It does look like there are a number of remedies open to him, and I'm sure he'll be back in touch with Elaine to get more advice on these in due course. That concludes our webinar for today. We have only just scratched the surface of public access rights. There is so much more we could have spoken about, so we're happy to take any questions you might have. If you want to drop us an email, our emails are on the screen there. Please do get in touch, and we hope to see you in a future webinar. Thank you.
Thank you.